How does a trust offer more protection? Well, let me count the ways. Actually, I'm probably going to give you my top 5. But before I do, I'd like you to imagine a friend going through what would otherwise be a challenging what if scenario that creeps into their lives: an illness of a partner, um, an accident that has put somebody in a coma, God forbid. And their lives would otherwise have been turned upside down, except you shared our video, and that helped them dramatically. We would appreciate that, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us so together we may help some folks along the way. Now, my top 5 reasons why trusts offer more protection is, first, it's a private document. It's not going to be known to the entire world or accessible to the entire world and predatory people, which may or may not be within your own family. Sorry to say. 2, it is valid the day you sign it. Now, this document, because it's a contract and you've signed it, it is valid then. Cannot be invalidated later via a court, unlike a will, which can be. It does avoid the use of a power of attorney at the point of incapacity for every financial institution, which can be extremely cumbersome and time-consuming. If you've never had to use a power of attorney before, oftentimes that process of just submitting a power of attorney, going to the legal department for review, takes a lot of time, and they're hesitant to provide others with access to the accounts of their customers. Privacy laws have become more restrictive in so many different reasons. And to that end, if the asset instead was owned by a trust, your trustee steps right into the footsteps. Is really a separate thing that I indicated, because it really applies at both incapacity and passing. There's no freezing of your assets. There's no delay. And it just happens automatically. In addition, when there are expenses that need to be paid, if someone doesn't have access as a power of attorney or as a executor later, and they have to wait for the okay from either a back office financial institution to get designated through the court, they'd have to pay expenses out of pocket, then to only wait to get reimbursed later. It's kind of a downside, right? That's sort of my 3 and 4 combined. And 5th, which I think most people recognize, is that a trust, unlike a will, does avoid the probate process altogether. Some states around the country are more difficult and costly than others when it comes to the probate process. But nevertheless, if you have a trust, you avoid that extra step, which typically translates into more time, expense, and typically a headache too. The probate process restricts folks in distributing the assets of the estate until after a creditor period has ended. In the states where I practice, that could be 7 or 8 months before they can distribute everything to the beneficiaries. And so who does that protect? The creditors of the potential creditors of the estate. Even if there are none, you still have to wait that period of time. So those are some of the highlights as to how a trust is more protective of the family. I'm going to add a bonus 6th one. It is much easier to add an extra level of protection for your beneficiaries under a trust than a will. And by that, I mean creating sort of what we call a legacy trust for the next generations, where they can get creditor insulation throughout their lifetime. While you can do this under a will, and we have, it's a bit more cumbersome in how it administratively works with all of the assets. It is much smoother to do so through your trust to a trust for your beneficiaries. So we hope that you've learned something new here today and that you choose to share. And as always, please Take care.